Okay, good evening po sa lahat ng makapanood ng video nito. Magandang araw sa lahat ng nanonood sa ibang ibayo na labas ng Pilipinas. So this video is purely reading lang po na ating Republic Act 10173 or known as the Data Privacy Act of 2012. Ito po yung ating ito po yung magiging basihan po natin regarding po doon sa mga hinihingi na mga suki card. So dito po natin makikita kung anong pwede nating articles dito sa batas na ito ang pwede natin magamit para maproteksyonan po natin ang ating mga medical record po. So, huwag na natin patagalin at mahaba-haba po itong Republic Act na ito. Hoping na maganda ang ating audio at sana walang wala naman sana check muna ako. Okay, hold on. Checking. 1, 2, 3. Hello? Checking. Let me check. Wala akong audio. Okay, meron. Sa makarinig check. Okay. Wala akong audio. Okay, sa makarinig po
Wala akong audio.
Okay na. So far, maganda ang ating audio. Sana hindi siya sana hindi siya magloko. Sana magtuloy-tuloy ang ating audio. Para hindi po masayang ang ating pagbabasa ng RA 10173 po. Okay, proceed po tayo doon sa reading of content ng Republic Act 10173 known as Data Privacy Act. So, tingnan po natin sa banda rito nakalagay yung mga regarding sa ating medical records. Republic of the Philippines National Privacy Commission. Implementing rules and regulation of Republic Act number 10173 known as the Data Privacy Act of 2012. Pursuant to the mandate of the National Privacy Commission to administer and implement the provisions of the Data Privacy Act of 2012 and to monitor and ensure compliance of the country with the international standards set for data protection, and for the following rules and regulations are hereby promulgated to effectively implement the provisions of the Act. So, proceed na po tayo dun sa content. Hindi na natin babasahin yung kanyang table of content. Rule number 1. Preliminary provisions. Section 1, title. These rules and regulations shall be known as the implementing rules and regulations of the Data Privacy Act of 2012 or the rules. Section 2, policy. These rules further enforce the Data Privacy Act and adopt generally accepted international principles and standards for personal data protection. They safeguard the fundamental human right of every individual to privacy while ensuring free flow of the information for innovation, growth, and national development. These rules also recognize the vital role of information and communications technology in nation building and enforce the state's inherent obligation to ensure that personal data in information and communication system in the government and in the private sectors are secured and protected. Section 3, definitions. Whenever used in these rules, the following terms shall have the respective meanings hereafter set forth. A. Act refers to Republic Act number 10173 known as the Data Privacy Act of 2012. B. Commission refers to the National Privacy Commission. C. Consent Consent of the data subject refers to any freely given, specific, informed indication of will whereby the data subject agrees to the collection and processing of his or her personal, sensitive personal, or privileged information. Consent shall be evidenced by written, electronic, or recorded means. It may be it may also be given on behalf of a data subject by a lawful representative or an agent specifically authorized by the data subject to do so. Letter D. Data subject refers to an individual whose personal, sensitive, personal, or privileged information is processed. Letter E. Data processing systems refers to the structure and procedure by which personal data is collected and further processed in an information and communications system or relevant filing system, including the purpose and intended output of the processing. Letter F. Data sharing is the disclosure of or transfer to a third party of personal data under the custody of a personal information controller or personal information processor. In the case of the latter, such disclosure or transfer must have been upon the instructions of the personal information controller concerned. The term excludes outsourcing or the disclosure or transfer of personal data by a personal information controller to a personal information processor. Letter G. Direct marketing refers to communication by whatever means of any advertising or marketing material which is directed to particular individuals. Letter H, saglit lang at medyo nag-alanganin ng aking battery. Okay, letter H, filing system refers to any set of information relating to natural or juridical persons to the extent that although the information is not processed by equipment operating automatically in response to instructions given for that purpose, the set is structured either by reference to individuals or by reference to criteria relating to individuals in such a way that specific information relating to a particular individual is readily accessible. Information, letter I, information and communications system refers to a system for generating, sending, receiving, storing, or otherwise processing electronic data messages or electronic documents and includes the computer system or other similar device by which data is recorded, transmitted, or stored, and any procedure related to the recording, transmission, or storage of electronic data, electronic message, or electronic document. Letter J, personal data refers to all types of personal information. Letter K, personal data breach refer to a breach of security leading the accidental or unlawful destruction, loss, alteration, unauthorized disclosure of or access to personal data transmitted, stored, or otherwise processed. Letter I, personal information refers to any information whether recorded in a material form or not, from which the identity of an individual is apparent or can be reasonably and directly ascertained by the entity holding the information, or when to put together with other information would directly and certainly identify an individual. Letter M, personal information controller refers to a natural or juridical person or any other body who controls the processing of personal data or instructs another to process personal data on its behalf. The term excludes first, a natural or juridical person or any other body who performs such functions as instructed by another person or organization. Or second, a natural person who processes personal data in connection with his or her personal, family, or household affairs. There is control if the natural or juridical person or any other body decides on what information is collected or the purpose or extent of its processing. N. Personal Information Processor refers to any natural or juridical person or any other body to whom a personal information controller may outsource or instruct the processing of personal data pertaining to a data subject. O. Processing refers to any operation or any set of operations performed upon personal data including but not limited to the collection, recording, organization, storage, updating or modification, retrieval, consultation, use, consolidation, blocking, erasure or destruction of data. Processing may be performed through automated means or manual processing if the personal data are contained or are intended to be contained in a filing system. Profiling refers to any form of automated processing of personal data consisting of the use of personal data to evaluate certain personal aspects relating to a natural person, in particular to analyze or predict aspects concerning that natural person's performance at work, economic situation, health, personal preferences, interests, reliability, behavior, location, or movements. Letter Q. Privileged information refers to any and all forms of data which, under the rules of court and other pertinent laws, constitute privileged communication. Okay. There are public authority refers to any government entity created by the Constitution or law and vested with law enforcement or regulatory authority and functions. Letter S. Security incident is an event or occurrence that affects or tends to affect data protection or may compromise the availability, integrity, and confidentiality of personal data. It includes incidents that would result to a personal data breach if not for safeguards that have been put in place. T. Sensitive personal information refers to personal information. First, okay tandaan natin ito. Medyo magandang ano to. Sensitive personal information refers to personal information first about an individual's race, ethnic origin, marital status, age, color, and religious, philosophical, or political affiliations. Second, about an individual's health, education, genetic, or sexual life of a person, or to any proceeding for any offense committed or alleged to have been committed by such individual, the disposal of such proceedings, or the sentence of any court in such proceedings. Third, issued by government agencies peculiar to an individual, which includes but is not limited to social security numbers, previous or current health records, licenses or its denials, suspension or revocation, and tax returns. And fourth, specifically established by an executive order or an act of Congress to be kept classified. Mhm. number 3 yung ano. Okay. Rule number 2, scope of application. Section 4, scope. The Act and these rules apply to the processing of personal data by any natural and juridical person in the government or private sector. They apply to an act done or practice and engaged in and outside of the Philippines if A. The natural or juridical person involved in the processing of personal data is found or established in the Philippines. Letter B. The act, practice, or processing relates to personal data about a Philippine citizen or Philippine resident. Letter C. The processing of personal data is being done in the Philippines, or letter D. The act, practice, or processing of personal data is done or engaged in by an entity with links to the Philippines with due consideration to international law and committee, such as but not limited to the following. First, use of equipment located in the country or maintains an office, branch, or agency in the Philippines for processing of personal data. Second, a contract is entered in the Philippines. Third, a juridical entity unincorporated in the Philippines but has central management and control in the country. Fourth, an entity that has a branch, agency, office, or subsidiary in the Philippines and the parent or affiliated of the Philippine entity has access to personal data. Fifth, an entity that carries on business in the Philippines. Six, an entity that collects or holds personal data in the Philippines. Section 5. Special cases. The Act and these rules shall not apply to the following specified information, only to the minimum extent of collection, access, use, disclosure, or other processing necessary to the purpose, function, or activity concerned. A. Information processed for purpose of allowing public access to information that fall within matters of public concern pertaining to: first, information about any individual who is or was an officer or employee of government that relates to his or her position or functions, including: first, the fact that the individual is or was an officer or employee of the government. Letter B, the title, office address, and office telephone number of the individual. Letter C, the classification, salary range, and responsibilities of the position held by the individual. And D, the name of the individual on a document he or she prepared in the course of his or her employment with the government. Okay. Second, information about an individual who is or was performing a service under contract for a government institution, but only insofar as it relates to such service, including the name of the individual and the terms of his or her contract. Number 3, information relating to a benefit of a financial nature conferred on an individual upon the discretion of the government, such as the granting of license or permit, including the name of the individual and the exact nature of the benefit, provided that they do not include benefits given in the course of an ordinary transaction or as a matter of right. Letter B. Personal information processed for journalistic, artistic, or literary purpose in order to uphold freedom of speech, of expression, or of the press, subject to requirements or other applicable law or regulations. Letter C. Personal information that will be processed for research purpose, intended for a public benefit, subject to the requirements of applicable laws, regulations, or ethical standards. Letter D. Information necessary in order to carry out the function of public authority in accordance with a constitutionally or statutorily mandated function pertaining to law enforcement or regulatory function, including the performance of the functions of the independent central monetary authority, subject to restrictions provided by law. Nothing in this act shall be construed is having amended or repealed Republic Act Number 1405, otherwise known as the Secretary of Bank Deposits Act, Republic Act Number 6426, otherwise known as the Foreign Currency Deposit Act, and Republic Act Number 9510, other known as the Credit Information System Act or CISA. Letter E. Information necessary for banks, other financial institutions under the jurisdiction of the Independent, Central Monetary Authority or Bangko Sentral ng Pilipinas, and other bodies authorized by law to the extent necessary to comply with Republic Act Number 9510 or CISA, Republic Act Number 9160 as amended, otherwise known as the Anti-Money Laundering Act, and the other applicable laws. Personal information originally collected from residents of foreign jurisdictions in accordance with the laws of those foreign jurisdictions, including any applicable data privacy laws, which is being processed in the Philippines. The burden of proving the law of the foreign jurisdiction falls on the person or body seeking exemption. In the absence of proof, the applicable law shall be presumed to be the act, and these rules, provided that the non-applicability of the act or these rules do not extend to personal information controllers or personal information processors who remain subject to the requirements of the implementing security measures for personal data protection. Provided further that the processing of the information provided in the preceding paragraphs shall be exempted from the requirement of the Act only to the minimum extent necessary to achieve the specific purpose, function, or activity. Section 6. Protection afforded to data subjects. A. Unless directly incompatible or inconsistent with the preceding sections in relation to the purpose, function, or activity of the non-applicability concern, the personal information controller or personal information processor shall uphold the rights of data subjects and adhere to general data privacy principles and the requirements of the lawful processing. Letter B. The burden of proving that the Act and these rules are not applicable to a particular information falls on those involved in the processing of personal data or the party claiming the non-applicability. In all cases, the determination of any exemption shall be liberally interpreted in favor of the rights and interests of the data subject. Section 7. Protection afforded to journalists and their sources. A. Publishers, editors, or duly accredited reporters or any newspaper, magazine, or periodical or general circulation shall not be compelled to reveal the source of any news report or information appearing in said publication if it was related in any confidence to such publisher, editor, or reporter. B. Publishers, editors, or duly accredited reporters who are likewise personal information controllers or personal information processors within the meaning of the law are still bound to follow the Data Privacy Act and related issuance with regard to the processing of personal data, upholding rights of their data subjects, and maintaining compliance with other provisions that are not incompatible with the protection provided by the Republic Act Number 53. Rule number 3. National Privacy Commission. Section 8. Mandate. The National Privacy Commission is an independent body mandated to administer and implement the Act and to monitor and ensure compliance of the country with international standards set for personal data protection. Section 9. Functions. The National Privacy Commission shall have the following functions. A. Rulemaking. The Commission shall develop, promulgate, review, or amend rules and regulations for the effective implementation of the Act. This includes, first, recommending organizational, physical, and technical security measures for personal data protection, encryption, and access to sensitive personal information maintained by government agencies considering the most appropriate standard recognized by the information and communications technology industry as may be necessary. Second, specifying electronic format and technical standards, modalities, and procedures for data portability as may be necessary. Number three, issuing guidelines for organizational, physical, and technical security measures for personal data protection, taking into account the nature of the personal data to be Hello. Sana okay. Wish. Checking ko lang. Check ko lang. Check ko lang. Okay ako rito pero pagdating sa sa aking monitor na wala na ako. Na, ito, wala yung aking live sa ensuring. Mhm. Tapos, letter C, public. Okay. Sa ensuring. Okay, dito ako naputo sa Tapos, saglit lang ha. Try ko lang. Saan na kaya ako naputo kanina? Privacy Commission. Hold on, Section 8, mandate. The National Privacy Commission. Teka lang at nawala ang aking para hindi na ako magre-relive. Laki ang nawala. Laking nawala. Letter E, information. Saan ako? Number 9510, other known as the Credit Information System Act or CISA. Lang. Balikan na natin. Nawala kasi yung aking connection kaya bigla akong nawala sa Anyway, tuloy ko na lang din doon na lang tayo. Babalikan ko na lang dito sa part sa public education. Okay, balik tayo sa public education, sa letter C. Sana may mag-comment kung okay ba, kung naririnig nyo ba ako or what. Kasi yung aking monitor dito, hindi ko siya ganun ka-reliable. Mahina masyado yung aking net. Kaya please po, favor, paki-comment kung okay po ba. So, balik tayo sa letter C, public education. Necessary or appropriate efforts to inform and educate the public of data privacy, data protection, and fair information rights and responsibilities. This includes, first, publishing on a regular basis a guide to all laws relating to data protection. Number two, publishing a compilation of agency system of records and notices, including index and other finding aids. Number three, coordinating with other government agencies and the private sector on efforts to formulate and implement plans and policies to strengthen the protection of personal data in the country. Letter D, compliance and monitoring. Kamusta ang aking kamusta ang aking audio para hindi ko na alam kung ano nangyayari sa aking sa live pa ba ako? Okay. Sana okay ang aking audio. Hindi ko na alam kung ano nangyayari sa aking sa live pa ba ako? Okay. So, okay, letter D. Okay. So far, okay naman yung aking Hold on. Okay. Letter D, compliance and monitoring. The Commission shall perform compliance and monitoring functions to ensure effective implementation of the Act, these rules, and other issuance. This includes, number 1, ensuring compliance by personal information controllers with the provision of the Act. Number 2, monitoring the compliance of all government agencies or instrumentalities as regards their security and technical measure, and recommending the necessary action in order to meet minimum standards for protection of personal data pursuant to the Act. Number 3, negotiating and contracting with other data privacy authorities or other countries for cross-border application and implementation of respective privacy laws. Number 4, generally performing such as may be necessary to facilitate cross-border enforcement of data privacy protection. And number 5, managing the registration of personal data processing systems in the country, including the personal data processing system of the contractors and their employees, entering into contracts with government agencies that involves accessing or requiring sensitive personal information of at least 1,000 individuals. Okay. Letter E. Complaints and investigations. The Commission shall adjudicate on complaints and investigations on matters affecting personal data, provided that in resolving any complaint or investigation, except where amicable settlement is reached by the parties, the Commission shall act as a collegial body. This includes, first, receiving complaints and instituting investigations regarding violations of the Act. These rules and other issuance of the Commission, including violations of the rights of the data subjects and other matters affecting personal data. Number 2, summoning witnesses and requiring the production of evidence by a subpoena juris secum for the purpose of collecting the information necessary to perform its function under the Act, provided that the Commission may be given access to personal data that is subject in any complaint. Number 3, facilitating or enabling settlement of complaints through the use of alternative dispute resolution processes and adjudicating on matters affecting any personal data. Number 4, preparing reports on the disposition of complaints and the resolution of any investigation. It initiates and in cases it deems appropriate, publicizing such reports. Okay, letter F, enforcement. The Commission shall perform all acts as may be necessary to effectively implement the Act, these rules and its other issuances, and to enforce its orders, resolutions, or decisions, including the imposition of administrative sanctions, fines, or penalties. This includes, number 1, issuing compliance or enforcement orders. Number 2, awarding indemnity on matters affecting any personal data or rights of data subjects. Number 3, issuing cease and desist orders or imposing a temporary or permanent ban on the processing of personal data upon finding the processing will be detrimental to national security or public interest, or if it is necessary to preserve and protect the rights of data subjects. Number 4, recommending to the Department of Justice the prosecution of crimes and imposition of penalties specified in the Act. Number 5, compelling or petitioning any entity, government agency, or instrumentality to abide by its order to take action on a matter affecting data privacy. Imposing administrative fines for violation of the Act, these rules, and the other issuances of the Commission. Okay, letter G, other functions. The Commission shall exercise such other functions as may be necessary to fulfill its mandate under the Act. Section 10. Administrative Issuances. The Commission shall publish or issue official directives and administrative issuances, orders, and circulars which include a. Rules of procedures in the exercise of its quasi-judicial functions, administrative services and filing fees. Letter C. Procedure for registration of administrative issuances consistent with its mandate and other functions. Section 11. Reports and information. Okay. The Commission shall report annually to the President and Congress regarding its activities in carrying out the provisions of the Act, these rules, and its other issuances. It shall undertake all efforts it deems necessary or appropriate to inform and educate the public of data privacy, data protection, and fair information rights and responsibilities. Section 12. Okay. Confidentiality of personal data. Members, employees, and consultants of the Commission shall ensure that all times the confidentiality of any personal data that come to their knowledge and possession, provided that such duty of confidentiality shall remain even after their term, employment, or contract has ended. Section 13. Organizational structure. The Commission is attached to the Department of Information and Communications Technology for policy and program coordination in accordance with Section 38(3) of Executive Order Number 292, Series 87, also known as the Administrative Code of 1987. The held by a privacy commissioner who shall act as chairman of the commission. The privacy commissioner must be at least 35 years of age and of good moral, unquestionable integrity, and known probity, and a recognized expert in the field of information technology and data privacy. The privacy commissioner shall enjoy the benefits and emoluments equivalent to the rank of secretary. The privacy commissioner shall be assisted by two deputy privacy commissioners. One shall be responsible for data processing systems, while the other one be responsible for policies and planning. The deputy privacy commissioners must be recognized experts in the field of information and communications technology and data privacy. They shall enjoy the benefits, privileges, and emoluments equivalent to the rank of Undersecretary. Section 14. Secretariat. The Commission is authorized to establish a Secretariat which shall assist in the performance of its functions. The Secretariat shall be headed by an executive director and shall be organized according to the following offices. A. Data Security and Compliance Office. Letter B. Legal and Enforcement Office. Letter C. Finance and Administrative Office. Letter D. Privacy Policy Office. And letter E. Public Information and Assistance Office. Majority of the members of the Secretariat, insofar as practicable, must have served for at least 5 years in any agency of the government that is involved in the processing of personal data, including but not limited to the following offices: Social Security System or SSS, Government Service Insurance System or GSIS, the Land Transportation Office or LTO, the Bureau of Internal Revenue or BIR, the Philippine Health Insurance Corporation or PhilHealth, the Commission on Elections or COMELEC, the Department of Foreign Affairs or DFA, the Department of Justice or DOJ, and the Philippine Postal Corporation or PhilPost. The organizational structure shall be subject to review and modification by the Commission, Interception, share screen ulit ako. Nawala ako sa StreamYard. Okay. Nawala ang aking signal. Saan ako nag-stop kanina? Mhm. Live ako live. Naka-live. Hindi pala 1 minute. Okay. Saan ako? And okay. Majority members. Okay. Wala ako na naman. The organization. Section 15. Okay. Majority. Section 15. Okay. Okay. Okay, nakuha pa yung sa majority. So, balik tayo dito sa next. Ulit. Okay. Ulitin ko dito sa page 15. Okay, ulit ako sa page 15. Type. Lang ta. Wala yung aking monitor. Okay. Okay. So, okay na. So, back tayo dito sa my page 15. Dito sa my majority. Okay. Oops. Okay. Okay. Majority of the members of the Secretariat, in so far as practicable, must have served for at least 5 years in any agency of the government that is involved in the processing of personal data, including but not limited to the following offices: the Social Security System or SSS, the Government Service Insurance System or GSIS, the Land Transportation Office or LTO, the Bureau of Internal Revenue, the PhilHealth Insurance Corporation, the Commission on Election, the COMELEC Department of Department of Foreign Affairs or DFA, the Department of Justice or DOJ, and the Philippine Postal Corporation or the PhilPost. The organizational structure shall be subject to review and modification by the Commission, including the creation of new divisions and units. It may be deemed necessary and shall appoint officers and employees of the Commission in order with civil service law, rules, and regulations. Okay, Section 15. Effect of lawful performance on duty. The Privacy Commissioner, the Deputy Commissioners, or any persons acting on their behalf or under their direction shall not be civilly liable for acts done in good faith in the performance of their duties, provided that they shall be liable for willful or negligent acts which are contrary to law, morals, public policy, and good customs, even if they acted under orders or instructions of superiors. Provided further that in case of a lawsuit is filed against them in relation to the performance of their duties, where such performance is lawful, he or she shall be reimbursed by the Commission for reasonable cost of litigation. Section 16. The Magna Carta for Science and Technology Personnel. Qualified employees of the Commission shall be covered by Republic Act Number 8349, which provides a Magna Carta for scientists, engineers, researchers, and other science technology personnel in the government. Rule 14, Data Privacy Principles. Okay, Section 17, General Data Privacy Principles. The processing of personal data shall be allowed subject to compliance with the requirements of the Act and other laws allowing disclosure of information to the public and adherence to the principles of transparency, legitimate purpose, and proportionality. Section 18, Principles of Transparency, Legitimate Purpose, and Personality. The processing of personal data shall be allowed subject to adherence to the principles of transparency, legitimate purpose, and proportionality. A. Transparency. The data subject must be aware of the nature, purpose, and extent of the processing of his or her personal data, including the risks and safeguards involved. The identity of personal information controller, his or her or public policy. Letter C, proportionality. The processing of information shall be adequate, relevant, suitable, necessary, and not excessive in relation to a declared and specified purpose. Personal data shall be processed only if the purpose of processing could be not reasonably be fulfilled by other means. Section 19. General Principles in Collection, Processing, and Retention. The processing of personal data shall adhere to the following general principles in the collection, processing, and retention of personal data. A. Collection must be for a declared, specified, and legitimate purpose. First, consent is required prior to the collection and processing of personal data, subject for exemptions provided by the Act and the other applicable laws and regulations. When consent is required, it must be time-bound in relation to the declared, specified, and legitimate purpose. Consent given may be withdrawn. Number two, data subject must be provided specific information regarding the purpose and extent of processing, including, where applicable, the automated processing of his or her personal data for profiling or processing for direct marketing and data sharing. Number three, purpose should be determined and declared before or as soon as reasonably practicable after collection. Number four, only personal data that is necessary and compatible with declared, specified, and legitimate purpose shall be collected. Letter B. Personal data shall be processed fairly and lawfully. First, processing shall uphold the rights of the data subject, including the rights to refuse, withdraw, consent, or object. It shall likewise be transparent and allow the data subject sufficient information to know the nature and extent of processing. Number two, information provided to a data subject must always be in clear and plain language to ensure that they are easy to understand and access. Must be in manner compatible with declared, specified, and legitimate purpose. Okay. Number four, processed personal data should be adequate, necessary in relation to the purpose for which they are processed. Number five, processing shall be undertaken in a manner that ensures appropriate privacy and should be accurate and where necessary for a declared, specified, and legitimate purpose, kept up to date. Two, inaccurate or incomplete data must be rectified, supplemented, destroyed, or their processing restricted. Letter D, personal data shall not be retained longer than necessary. First, retention of personal data shall only for as long as necessary. A, for the fulfillment of the declared, specified, and legitimate purpose, or when the processing relevant to the purpose has been terminated. Letter B, the establishment, exercise, or defense of legal claims. Or C, for legitimate business purposes, which must be consistent with standards followed by the applicable industry or approved by appropriate government agency. Number two, retention of personal data shall be allowed in cases provided by law. Number three, personal data shall be disposed or discarded in a secure manner that would prevent further processing, unauthorized access, or disclosure to any other party or the public, or prejudice the interest of the data subjects. Any authorized further processing shall have adequate safeguards. First, personal data originally collected for a declared, specified, or legitimate purpose may be processed further for historical, statistical, or scientific purposes, and in cases laid down in law, may be stored for longer periods subject to implementation Nawala na naman ang aking signal. Okay. Tapos may signal kaya nawala na naman ang aking signal. Mhm. Okay, anyway, okay naman na yata ako. Okay na. So, back to live. Okay, okay na. So, nag-stop ako dito kanina. Letter B. Data sharing. Parang nawala yata dito sa taas. Dito ako sa taas nawala. From the Section 20, the General Principles for Data Sharing. Further processing of personal data collected from a party other than the data subject shall be allowed under any of the following conditions. A. Data sharing shall be allowed when it is expressly authorized by law, provided that there are adequate safeguards for data privacy and security, and processing adheres to principles of transparency, legitimate purpose, and proportionality. Letter B. Data sharing shall be allowed in the private sector if the data subject consents to data sharing, and the following conditions are complied with. First, consent for data sharing shall be required even when the data is to be shared with an affiliate or mother company or similar relationships. Second, data sharing for commercial purposes, including direct marketing, shall be covered by a data sharing agreement. A. The data sharing agreement shall establish adequate safeguards for data privacy and security and uphold the rights of the data subjects. Letter B. The data sharing agreements shall be subject to review by the Commission on its own initiative or upon complaint of the data subject. Letter number 3. The data subject shall be provided with the following information prior to collection or before data is shared. A. Identity of the personal information controllers or personal information processors that will be given access to the personal data. Letter B. Purpose of data sharing. Letter C. Categories of personal data concerned. Letter D. Intended recipients or categories of recipients of the personal data. Letter E. Existence of the rights of data subjects, including the rights to access and correction and the right to object. Letter F. Other information that would sufficiently notify the data subject of the nature and extent of data sharing and the manner of processing. Okay, number 4. Further processing of shared data shall adhere to the data privacy principles laid down in the Act, these rules, and other issuances of the Commission. Letter C. Data collected from parties other than the data subject for purpose of research shall be allowed when the personal data is publicly available or has the consent of the data subject for the purpose of research, provided that adequate safeguards are in place and no decision directly affecting the data subject shall be made on the basis of the data collected or processed. The rights of the data subject shall be upheld without compromising research integrity. Letter D. Data sharing between government agencies for the purpose of a public function or provision of a public service shall be covered a data sharing agreement. Any or all government agencies party to the agreement shall comply with the Act, these rules, and all other issuance of the Commission, including putting in place adequate safeguards for data privacy and security. Number 2, the data sharing agreement shall be subject to review of the Commission on its own initiative or upon complaint of the data subject. Okay. Rule number 5, lawful processing of personal data. Um, Section 21. Criteria for lawful processing of personal information. Processing of personal information is allowed unless prohibited by law. For processing to be lawful, any of the following conditions must be complied with. A. The data subject must have given his or her consent prior to the collection or as soon as practicable and reasonable. Letter B. The processing involves the personal information of the data subject who is a party to a contractual agreement in order to fulfill obligations under the contract or to take steps at the request of the data subject prior to entering the said agreement. Letter C. The processing is necessary for compliance with a legal obligation to which the personal information controller is subject. Letter D. The processing is necessary to protect vitally important interests of the data subject, including his or her life and health. Dito kalagay letter D. The processing is necessary to protect vitally important interests of the data subject, including his or her life and health. Letter E. The processing of personal information is necessary to respond to national emergency or to comply with the requirements of public order and safety as prescribed by law. Letter F. The processing of personal information is necessary for the fulfillment of the constitutional or statutory mandate of a public authority, or the processing is necessary to pursue the legitimate interest of the personal information controller or by a third party or parties to whom the data is disclosed, except where such interests are overridden by fundamental rights and freedoms of the data subject, which require protection under the Philippine Constitution. Section 22. Sensitive personal information and privileged information. The processing of sensitive personal and privileged information is prohibited, except in any of the following cases. A. Consent is given by data subject or by the parties to the exchange of privileged information prior to the processing of the sensitive personal information or privileged information, which shall be undertaken pursuant to a declared, specified, and legitimate purpose. Letter B. The processing of a sensitive personal information or privileged information is provided by the existing laws and regulations, provided that said laws and regulations do not require the consent of the data subject for the processing and guarantee the protection of personal data. Letter C. The processing is necessary to protect the life or health of the data subject or another person, and the data subject is not legally or physically able to express his or her consent prior to the processing. Letter D. The processing is necessary to achieve the lawful and non-commercial objectives of public organizations and their associations, provided that, first, processing is confined and related to the bona fide members of these organizations or their associations. Number two, the sensitive personal information are not transferred to third parties. And three, consent of the data subject was obtained prior to processing. Let of medical treatment. Provided that it is carried out by a medical practitioner or a medical treatment institution and an adequate level of protection of personal data is ensured, or the processing concerns sensitive personal information or privileged information necessary for the protection of lawful rights and interests of natural or legal persons in court proceedings, or the establishment, exercise, or defense of legal claims, or when provided to government or public authority pursuant to a constitutional or statutory mandate. Section 23. Okay. Tanggalan ako ng tubig. Section 23, Extension of Privileged Communication. Personal information controllers may invoke the principle of privileged communication over privileged information that they lawfully control or process. Subject to existing laws and regulations, any evidence gathered from privileged information is inadmissible. When the Commission requires upon communication claimed to be privileged, the personal information controller concerned shall prove the nature of the communication in an executive session. Should the communication be determined as privileged, it shall be excluded from evidence. The content thereof shall not form part of the records of the case, provided that where the privileged communication itself is the subject of a breach or a privacy concern or investigation, it may be disclosed to the Commission but only to the extent necessary for the purpose of investigation without including the contents thereof in the records. Section 24, Surveillance of Suspects and Interception of Recording of Communications. Section 7 of Republic Act No. 9372, otherwise known as the Human Security Act of 2007, is hereby amended to include the condition that the processing of personal data for the purpose of surveillance, interception, or recording of communications shall comply with the Data Privacy Act, including adherence to the principles of transparency, proportionality, and legitimate purpose. Rule number 6. Security measures for the protection of personal data. Section 25. Data privacy and security. Personal information controllers and personal information processors shall implement reasonable and appropriate organizational, physical, and technical security measures for the protection of personal data. The personal information controller and personal information processor shall take steps to ensure that any natural persons acting under their authority who has access to personal data does not process them except upon their instructions or as required by law. The security measures shall aim to maintain the availability, integrity, and confidentiality of personal data and are intended for the protection of personal data against any accidental or unlawful destruction, alteration, and disclosure, as well as against any other unlawful processing. These measures shall be implemented to protect personal data against natural dangers such as accidental loss or destruction, and human dangers such as unlawful access, fraudulent, misuse, unlawful, destruction, alteration, and contamination. Section 26, Organizational Security Measures. Where appropriate, personal information controllers and personal information processors shall comply with the following guidelines for organizational security. A. Compliance officers. Any natural or juridical person or other body involved in the processing of personal data shall designate an individual or individuals who shall function as data protection officer, compliance officer, or otherwise be accountable for ensuring compliance with applicable laws and regulations for the protection of data privacy and security. Letter B. Data protection policies. Any natural or juridical person or other body involved in the processing of personal data shall implement appropriate data protection policies that provide for organization, physical, and technical security measures, and for such purpose, take into account the nature, scope, context, and other purposes of the processing, as well as the risks posed to the rights and freedoms of the data subjects. The policy shall implement data protection principles, both at the time of determination of the means for processing at the time of processing itself. The policies shall implement appropriate security measures that, by default, ensure only personal data which is necessary for the specified purpose of the processing are processed. They shall determine the amount of personal data collected, including the extent of processing involved, the period of their storage, and their accessibility. Third, the policies shall the police the police shall provide for documentation, regular review, evaluation, and updating of the privacy and security policies and practices. Records of processing activities. Any natural or juridical persons or other body involved in the processing of personal data shall maintain records that sufficiently describe its data processing system and identify the duties and responsibilities of those individuals who will have access to personal data. Records should include: first, information about the purpose of the processing of personal data, including any intended future processing or data sharing. Second, a description of all categories of data subjects, personal data, and recipients of such personal data that will be involved in the processing. 3. Procedures within the organization from the time of collection, processing, and retention, including the time limits for disposal or erasure of personal data. Number 4, a general description of organizational, physical, and technical security measures in place. Number 5, the name and contact details of the personal information controller, and where applicable, the joint controller, the its representative, and the compliance officer or data protection officer, or any other individual or individuals accountable for ensuring compliance with the applicable and security. Letter D. Management of human resources. Any natural or juridical person or other entity involved in the processing of personal data shall be responsible for selecting and supervising its employees, agents, or representatives, particularly those who will have access to personal data. The said employees, agents, or representatives shall operate and hold personal data under strict confidentiality if the personal data are not intended for public disclosure. This obligation shall continue even after leaving the public service, transferring to another position, or upon terminating their employment or contractual relations. There shall be capacity building, orientation, or training programs for such employees, agents, or representatives regarding privacy or security policies. Letter E. Processing of personal data. Any natural or juridical uh, person or other bodies involved in the processing of personal data shall develop, implement, and review: first, a procedure for the collection of personal data, including procedures for obtaining consent when applicable. Second, procedures that limit the processing of data to ensure that it is only to the extent necessary for the declared, specified, and legitimate purpose. Third, policies for access management, system monitoring, and protocols to follow during security incidents or technical problems. Fourth, policies and procedures for data subjects to exercise their rights under the Act. Fifth, data retention schedule including timeline or conditions for ensure disposal of records. Okay. Okay, letter F. Contracts with personal information processors. The personal information controller, through appropriate contractual agreements, shall ensure that its personal information processors, where applicable, shall also implement the security measures required by the Act of these rules. It shall only engage those personal information processors that provide sufficient guarantees to implement appropriate security measures specified in the Act, and these rules and ensure the protection of the rights of the data subject. Section 27. Uh, Physical security measures, where appropriate personal information controllers and personal information processors shall comply with the following guidelines for physical security. Policies and procedures shall be implemented to monitor and limit access to and activities in the room, workstation, or facility, including guidelines that specify the proper use of access to electronic media. Design of office space and work stations, including the physical arrangement of furniture and equipment, shall provide privacy to anyone processing personal data, taking into consideration the environment and accessibility to the public. The duties, responsibilities, and schedule of individuals involved in the processing of personal data shall be clearly defined to ensure that only the individuals actually performing official duties shall be in the room or workstation at any given time. Letter D. Any natural or juridical person or other body involved in the processing of personal data shall implement policies and procedures regarding the transfer, removal, disposal, and reuse of electronic media to ensure appropriate protection of personal data. Letter E. Policies and procedures that prevent the mechanical destruction of files and equipment shall be established. The room and workstation used in the processing of personal data shall, as far as practicable, be secured against natural disasters, power disturbances, external access, and other similar threats. Okay. Section 28. Guidelines for technical security measures. Where appropriate, personal information controllers and personal information processors shall adopt and establish the following technical security measures. A. A security policy with respect to the processing of personal data. B. Safeguard to protect their computer network against accidental, unlawful, or unauthorized usage. Any interference which will affect data integrity or hinder the functioning or availability of the system and unauthorized access through an electronic network. C. The ability to ensure and maintain the confidentiality, integrity, availability, and resilience of their processing systems and services. And D. Regular monitoring for security breaches and process both for identifying and accessing reasonably foreseeable vulnerabilities in their computer networks and for taking preventive, corrective, and mitigating action against security incidents that can lead to a personal data breach. Letter E. The ability to restore the availability and access to personal data in a timely manner in the event of a physical or technical incident. Letter F. A process for regularly testing, assessing, and evaluating the effectiveness of security measures. Letter G. Encryption of personal data during storage and while in transit, authentication process, and other technical security measures that control and limit access. Section 29. Appropriate level of security. Section 29. Hold on natin. Mahaba. Mahaba to. Mahaba pa nga to. Okay. Okay, balik tayo sa section Section 29. Okay. Section 29. Appropriate level of security. The Commission shall monitor the compliance of natural or juridical person or other body involved in the processing of personal data, specifically their security measures, with the guidelines provided in these rules and subsequent issuances of the Commission. In determining the level of security appropriate for a particular personal information, controller, or personal information processor, the Commission shall take into account the nature of the personal data that requires protection, the risk posed by processing, the size of the organization, and the complexity of its operations, current data privacy best practices, and the cost of security implementation. The security measures provided herein shall be subject to regular review and evaluation and may be updated as necessary by the Commission in separate issuances, taking into account the most appropriate standard recognized by the information and communication technology industry and data privacy best practices. So, rule number 7 tayo. Hold on ah. Check ko kung kayanin pa ng okay. Try natin. Rule number 7, security of sensitive personal information in government. Section 30, responsibility of heads of agencies. All sensitive personal information maintained by the government, its agencies, and instrumentalities shall be secured as far as practicable with the use of the most appropriate standard recognized by the information and communications technology industry, subject to these rules and other issuances of the Commission. The head of each government agency or instrumentality shall be responsible for complying with the security requirements and mentioned herein. The Commission shall monitor government agency compliance and may recommend the necessary action in order to satisfy the minimum standards. Section 31. Mouse na ako. Section 31. Requirements relating to access by agency personnel to sensitive personal information. A. On-site and online access. No employee of the government shall have access to sensitive personal information on government property or through online facilities unless he or she, the employee, has received a security clearance from the head of the source agency. The source agency is the government agency who originally collected the personal data. Nakabahaba para to. Marami pala itong ng Privacy Act na to. Okay. Number 2. A source agency shall strictly regulate access to sensitive personal information under its custody or control, particularly when it allows online access. An employee of the government shall only be granted a security clearance when the performance of his or her official functions or the provisions of a public service directly depends on and cannot otherwise be performed unless access to the personal data is allowed. Were allowed under the next preceding sections, online access to sensitive personal information shall be subject to the following conditions. A. An information technology governance framework has been designed and implemented. The employee is only given online access to sensitive personal information necessary for the performance of official functions or the provision of a public service. Letter B. Off-site access. Off-site access. Off-site access. Saan page ba ito? 30. Haba pa pala ito. Okay, so cut na lang muna natin dito muna to. So, bukas, next time ko na lang po ulit itutuloy itong off-site access para hindi po gaanong mahaba. So, ito po yung mahigit isang oras. Ito po yung half, hindi pa lang, nasa almost 3/4 pa lang po nitong RA 10173 or known as Data Privacy Act. So, tuloy na lang po next time pag may time po ulit. Sana may mapulot kayong information dito sa Data Privacy Act na ito. So, hanggang sa muli, paalam muna po.